very much. Thank you for being patient with this long calendar today.
They happen, they do happen.
All right, I used to like Mondays, holidays, because it used to feel like that was actually really a holiday instead of Friday. I don't like Monday holidays anymore. All right, thank you.
Sharon, can I approach on non-related real quick?
You may.
Doing great. It's just, you had the luck of a 2-box calendar. That's, you know.
All right. Give me 1 second. I need to get all my notes on this. Mr. Sachs, are you there? Now I'm ready to go off mute. Okay. Mr. Sachs, are you there? I know he was here this morning. Mr. Sachs, are you there? Calling case 343540, State of Nevada versus Kimball Austin Sachs. Mr. Sachs, are you there? Want me to continue it, or you want me to go forward?
Ma'am,
There we go. All right.
ma'am, I apologize. I apologize. I accidentally hit the on-call button when I hit the, I meant to hit the unmute button.
All right, not a problem. All right, calling case C 343540, State of Nevada versus Kimball Austin Sachs. I have Mr. Sachs present on Blue Jeans, and I have Ms. Rinetti here in the courtroom. I have this down for 2 motions that were filed by Mr. Sachs. One was defendant's motion for the court to provide the long overdue findings of fact, conclusions of law for 2 court filings from Judge Carly Kearney pursuant to EDCR Rule 1.90A4. And the second motion was defendant's motion to compel Prosecutor Dena Rinetti or the court administrator to provide the court model jury questionnaire and model jury instructions and grand jury rules and bench book pursuant to EDCR Rule 1.50 and voir dire the court pursuant to the Constitution of the United States. The court has read through everything. I am a new judge on this case, so I did in fact go back and look at the history of the case, and very specifically the transcript from the last hearing, as well as the motions and what was cited in the motions. And I am prepared to rule today, but they are your motions, Mr. Sachs. So is there anything other than what was contained in your motions that you would like the court to consider before I state what the court's inclinations are?
Well, what I would like to do is actually ask the questions that were contained in the motion for the jury instructions and other things like that, because the other one in my mind is pretty straightforward, meaning the findings of fact, conclusions of law. That's pretty straightforward. But again, I have specific questions to pose to the court with respect to that second motion, the one for the type instructions that would prepare me for a fair trial.
Okay. Mr. Sachs, it is not appropriate for you to question the court about things that involve legal issues. The court is not allowed, pursuant to the law, to provide you with legal advice. If you have questions in regards to model jury instructions or jury questionnaires, those are appropriately obtained by the jury instructions are online. You can find them by looking them up, or you can reach out to the self-help center and they can help you, but the court cannot provide you with legal advice, and it is inappropriate for you to ask the court questions, I can certainly answer procedural questions, but I cannot provide you with any advice that would be legal advice, which gets into the issue of why Miss Judge Kearney offered to provide you with standby counsel, I believe, to try and help you, assist you potentially in answering some of those questions that you might have. So that's where we're at, but it's not appropriate for you to ask me questions that would require the court to provide you with legal advice. So if you have any questions that would not require the court to provide you with legal advice, I am happy to answer those questions. With that understood.
Thank you.
Do you have any questions?
Thank you, ma'am. So really the follow-up would be is I fail to see how asking for the model jury questionnaire, the model jury instructions, the rules for the grand jury, and the bench book are advice in any way, shape, or form. My understanding is this is a public court and that these are public documents, and I'm just simply asking for the source because the 8th Judicial District Court does not provide these documents on the site that I could see, meaning the 8th Judicial District Court when you go to it. They actually have some type of assistance for civil cases, but they don't have anything for what I'm asking for criminal cases. So it seems to me that's actually unfair right off the bat. So again, I fail to see, ma'am, how does asking for the jury instructions, the jury questionnaire, the rules for the grand jury with respect to the roles and responsibilities of the prosecutor and the defendants and the bench book, how does that even come close to being or considered legal advice, ma'am?
Okay, and let me explain to you on two of those. The jury questionnaire is not something that is created by this department. The jury questionnaire is something that is created by jury services.
Ma'am, I can't hear you. You've gone silent.
We aren't muted, so it must be on your end. Can you hear me now?
I didn't touch yes, I can hear you, ma'am, but I didn't touch my phone, I assure you.
Okay. The jury questionnaire is not something that is provided by the department. The jury questionnaire is something that is created by jury services. If there is even a jury questionnaire that is done, ever since COVID, there has not been jury questionnaires that have been done. So, and usually that is something that is created by the attorneys that are involved in the case that is presented to the court. It is not something that the court creates. As it pertains to the jury instructions, there is a book of jury instructions that is available out there, and also similarly, those jury instructions are usually jury instructions that are presented to the court by the parties as to specific jury instructions that the parties either agree to and or that they don't agree to, that then the court, once they receive those jury instructions, does what's called settling the jury instructions and goes over the jury instructions with the parties prior to trial, and then before towards the end of trial, before we read the jury instructions to the actual jury, we do what's called settling the jury instructions to make sure that the jury instructions that are provided are in accordance with the facts and information that were provided during the trial. As it pertains to the bench book is created by the court and is the judge's own work product. All of us have different bench books that simply has statutes and court rules in it that we utilize for our benefit, and it's not something that is given out to the public, and it's not something that is appropriate to be given out to the public. It would be similarly if you had an attorney that was representing you, Mr. Sachs. It would be like me asking for that attorney to divulge his notes. It is something that is utilized in various different cases and is for the benefit of the judges to make sure that we cover all of the different things that we need to cover when we are handling a case. As it pertains to voir dire is similarly something that is that you create. Voir dire is a method of weeding out impartial or jurors that could be potentially partial And it's questions that you all come up with, that you can come up with on your own, that would be asked of jurors to assess their ability to fairly and impartially judge your case. There are very generalized questions that the court will ask, but pursuant to EDCR 7.70, it is a method by which you are attempting to weed out jurors in your case that might be biased or not impartial in your case. And so it's questions that you create on your own. And there is no basis for you to voir dire the court. The purpose of voir dire is, as I indicated, for you to pose questions to jurors. It is not to ask questions of the court. And that is pursuant to...
Ma'am, to just follow up on that, and thank you for that,
Sure.
is how can it be considered inappropriate for me to ask you, have you taken your oath, and what day did you take your oath, and specifically, where on file may I obtain a certified copy of your oath, ma'am?
Because that's not voir dire. That's not the purpose of voir dire. Voir dire, the purpose of voir dire is, and you can look up EDCR 7.70. EDCR 7.70 defines what voir dire is, and the purpose of voir dire is to ensure that you get a fair and impartial jury, and that is questions that you would pose to the jurors. By virtue of me sitting here, I have been deemed to have taken my oath by the Supreme Court of the state of Nevada. So my ability to sit here is created on my duty to take my oath, but I did take my oath on, I took the bench on January the 4th, which would have been a Monday. So January the 2nd of 2021 is the date that I took my oath of office. For your
And how do I get a certified copy, ma'am, of your oath?
I believe that those are I believe that those are on file with the county clerk, but I am not 100% sure, sir. I know that I took it,
All
I
right.
signed it, and I know that it was signed by the judge who I took my oath in front of. There was a secondary oath that was taken because I took the bench in 2021, so my investiture happened because we were in COVID time frame. My investiture happened in September of 2021, but my oath of office was taken January 2nd of 2021. I believe that it might be with the clerk of the court, or it might be with the registrar's office. Maybe, I know it was Lynn Goya for a while, but I'm not sure who would have that. So, but that's the information I can give you on that issue as it currently pertains. As it pertains to the court to provide your motion to provide the long overdue findings of fact and conclusions of law from Judge Kearney, there is no requirement pursuant to EDCR 1.90A4. It just says that judge has to issue a decision, which the judge did issue a decision in this case. And so she was not required to do findings of fact, conclusions of law. Findings of fact, conclusions of law are referenced in 1.90A5 after the trial on the matter has completed, or if there's an evidentiary hearing. But it's my understanding that there was no evidentiary hearing, nor was there any trial yet. So all she had to do was issue a decision, which she did issue that decision. And so therefore I was going to deny that motion as well. And I was going to, for all of the reasons that I've already stated on the record as to the other motion, I'm going to deny that motion as well. So.
Ma'am, I just have some follow-up questions. Then why did the other judges, meaning the previous judges, Judge Silva and Judge Lily Spells, provide me with the findings of fact, conclusions of law, if that's what you're maintaining, ma'am?
Because every judge is allowed to do things differently, and if they choose to issue findings of fact and conclusions of law, they may do so. They are not required to do so, though. Sometimes they will do, unless there are specific instances where they are required to do so, which is if it is a writ of habeas corpus, there is a requirement under, I wrote this down, give me 1 second here. I believe it's NRS 38.340 is the requirement for, if it's a writ of habeas corpus, that you are required to do findings of fact and conclusions of law. Findings of fact and conclusions of law will also be appropriate if you have a situation where the court actually made findings of fact. So if the court, and that is so that the appellate court will have a sufficient record to be able to see what the lower court did. So I don't know how, what the issues came up with in front of Judge Silva or Judge Spells. I am not in their heads. I did not speak to them about your case because that would be inappropriate for me to ask other judges what they did on your case. So, but I can tell you that if it is a writ of habeas corpus, or if there is an issue where, as I indicated before, an issue where the court feels that it's necessary to make findings of fact because they will need to, the appellate court will need to have those findings, then it would be appropriate in those instances to issue findings of fact and conclusions of law. But in this particular instance, from what I could see, your motion was a motion to dismiss based on jurisdictional grounds, which did not require findings of fact and conclusions of law, and that is the reason why Judge Kearney simply issued a decision. That is my guess. Again, I am not in Judge Kearney's mind, but that would be my take on the situation.
Thank you for that, ma'am. So you mentioned somewhere in that answer.
Mr. Sachs?
Yes. Yes.
I earned the title of judge. I would appreciate it if you used it. I'm not a ma'am.
I said ma'am. I didn't. I said ma'am.
I know. I know you said ma'am. I am a judge, or I am your honor. I am not ma'am.
All right. If it suits you, Judge, I'll go ahead and address it that way. So, Judge, in your answer, you said that Judge Kearney did say that it was written somewhere. I didn't see it written anywhere. Where would I find her written decision? Because I didn't get anything in writing. In other words, I'm not in receipt of that, Judge.
So, hold on. Let me pull your case up, and I'll tell you exactly where it is. Give me 1 second, Mr. Sachs. I just need to get to it. This is a pretty long history and odyssey, so give me 1 minute.
Thank you.
I looked at it last night. All right, so on September 5th of 2023, an order was entered. I will read it to you because it's relatively short. It says, "It is hereby ordered that the defendant's motion to correct the recorder's transcript of the hearing held on July 24th, 2023 pursuant to NRS 656-250 and motion to dismiss charges as the court is deprived of in personam jurisdiction pursuant to the contract clause of the United States Constitution and defendant's motion to acquire my complete case file that was due from the rogue attorney Ben Nadig on July 28, 2023, and to sanction Ben Nadig pursuant to NRS 7055, shall be court ordered matter set for status check for Mr. Nadig to provide confirmation that case filing was sent. Court indicated as to defendant's motion to correct recorder's transcript, it had the recorder review and correct any clerical errors and file an amended transcript with an errata attached explaining the changes made to the transcript. Court further ordered motion to dismiss charges denied." So that was signed on September 5th of 2023, and it is in Odyssey.
In Odyssey, I was not provided a copy. Is it not true that the orders and such things, documents like that, are they emailed to me via the normal way that I get notifications from the court?
No, if you are you need to register for file and serve, sir. And when you register for file and serve, then you will automatically receive anything that is filed into your case through that file and serve.
Thank you for that.
Yep.
The one follow-up that's very pressing, though, that I do need to ask the question,
Sure.
Judge, is what law of the case, other than what I've been, say, falsely charged with, the NRS 200.508, what other law of the case is going to be, say, mentioned or discussed to the jury? And I ask that question knowing ahead of time. In other words, seeing this as a very rigged game, ma'am, that's my position, is that the jurors are going to be instructed on the laws of the case. And so in order for me to prepare a proper defense and to obtain a fair trial as best as I can, I'm asking the question, Judge, what law of the case is going to be mentioned to the jurors, please?
And sir, we're not in trial. So you are being charged per the charges that have been issued against you, which I'm aware that you've already pled not guilty to those charges, correct?
That's correct.
All right, so you know the charges that are being brought against you. When you go to trial, in order for you to prepare for trial, you need to prepare to defend yourself on those charges as the statutory charges that were brought against you. And then you will create jury instructions because you're representing yourself, you will create jury instructions that you will provide to the court, and the prosecuting attorney's office will prepare jury instructions. Usually what happens when you have a defendant, usually they have a defense attorney that usually meets with the prosecuting attorney and goes over what they think are the appropriate jury instructions to provide to the jurors, and there's usually a group of stipulated jury instructions that you come up with, as well as non-stipulated instructions. The court listens to the evidence that is presented at the trial, and then based on the evidence that is presented at the trial, will instruct the jury based on the evidence that is presented at the trial as to what the jury instructions are. So I don't know as we sit here right now, because we haven't done trial, we haven't done a calendar call, we haven't done a pretrial. So until such time as you and Ms. Rinetti, or if you get standby counsel, but standby counsel is there specifically just to be standby counsel, so it's up to you. You did the Ferretta canvas, and you said that you wanted to represent yourself. You have that right to do that, but it is your responsibility to marshal your case, and it is not me telling you what law is going to be provided. Would be giving you legal advice, and I can't do that.
Ma'am, excuse me, forgive me, please, Judge, and it's such a force of habit, forgive me,
That's fine.
I have already read in previous filings from, I believe it was Ms. Joby at the time, she was the former prosecutor, is that she put in black and white English in words. She said it is and one of the previous judges said the same thing during a hearing. Both of them were they both said is that the jury decides the facts and the judge decides the law. And so again, looking ahead, like trying to plan this intelligent, like a sane, rational man, is that my understanding is before you say let the jurors deliberate, is that you're going to provide guidance on the law. So given that, I guess the best I can do at this moment, ma'am, or judge, is to file an oral motion for you to take judicial notice of NRS 41A.110 and NRS 49A.106, paragraph 6. Those are both for informed consent. In other words, that's part of my defense. And then to take judicial notice of NRS 126.036. That's my right to non-medical remedial care and, parental rights. And then NRS 200.5085, the right to non-medical remedial care. So I am, again, I'm making it, I move the court to take judicial notice of those NRS.
Mr. Sachs, I'm going to interrupt you. If you want to move the court for anything, file an appropriate motion. I do not decide things without an appropriate motion being brought before me and without the opportunity to have the other side to respond to the motion. We are here on the two motions that you had teed up for today. I've made my decision on those motions. As it pertains to what you are asking, I can tell you right now, the court cannot take judicial notice of it can take judicial notice of a statute, but it cannot take judicial notice of whether or not that statute would be applicable in your case. That is certainly one of the stipulated instructions. So, i.e., this is the one procedural benefit I will give you right now, is you could state to the court that you want the court to give a jury instruction on one of those statutes that you just cited. And so you would present that to the court at the time of trial as a non-stipulated jury instruction. It then would be up to you to prove with evidence at the time of trial why that jury instruction should be given to the jurors. The same way that the state is going to say, we're bringing charges under this, and they have to prove beyond a reasonable doubt that those charges are appropriate, and those would be instructions that they would give me to read to the jurors based on the facts as they come out during the time of trial. So I cannot take judicial notice as to whether or not the facts that come out at trial are applicable for me to give a jury instruction based on a statute. Now, you can certainly present that to the court as one of the jury instructions that you would like the court to give to the jurors, because yes, you are right. The jurors decide the facts. The court provides the jurors with an outline of what the law is in utilizing those facts to come to a decision. But it's up to what comes out at trial as to what instructions are appropriate to give to the jurors. Does that make better sense, sir?
It does, and thank you for that, Judge. And then I guess the last thing I just want to follow up on is, with respect to Ms. Rinetti, are prosecutors legally and ethically obligated in every case to pursue justice by discerning the truth and protecting the rights of all? In other words, victims, defendants, and the community. Is that fair to say? Is that true? Yes or no, Judge?
I would say that a jury trial, that there are jury instructions that say that the purpose of a jury trial is to ascertain the truth. And I would say that a prosecuting attorney as well as a defense attorney has rules of professional conduct that they are required to abide by, and ethical ethical oaths that they take as officers of the court, that they take and are required to abide by. So I don't think that I would agree with your word protect, but I would agree that they are required to abide by ethical obligations according to the rules of professional conduct.
Thank you for that, Judge. So the follow-up to that would be, was Ms. Rinetti, when I sent her no less than 3 or 4 emails to ask about these things that are in this motion, did she have an obligation or duty to answer my emails?
Your Honor, I will just say this. I've had numerous email correspondence from the defendant. When necessary, I've responded. For instance, he requested, he was missing 2 pages of a declaration of arrest. I provided that. There are things that he's communicating to me that just are inappropriate and I will not be engaging.
Ms. Rinetti has an obligation to respond if it is appropriate within her ethical obligations, the same way that you would be asking an attorney, if you had an attorney that would be asking her questions, that it would be appropriate for her to respond to that attorney. So if it's not a question that she would, and I don't know the context of the questions that you are asking, and I'm not going to get into the weeds on that because I need to complete this hearing, and you can certainly, if there's something that you feel that was not appropriately responded to, you can put that before the court and I can make a decision on it. But Ms. Rinetti, any prosecutor that's on the case, as well as yourself acting in pro per as your own attorney, both sides have ethical obligations, and so you can find those if you were to go on to the Nevada State Legislature, sir, and look up rules of professional conduct. You can see what the rules of professional conduct are, since it's very clear to me that you like to do research, which, and that's perfectly acceptable, and I commend you for doing that. So if you wanted to look up the rules of professional conduct, you can do that. Okay?
Well, in the interest of settlement and closure of this matter, what is the actual U.S. dollar fine for the 3 felony counts charged against my straw man?
He's at, Judge, he's communicated to my office. He asked that question. I asked him if he's talking about the fine amount that's associated with the felonies that he's charged with.
Yes.
He said no. He talks about crimes or commerce, and I have not responded.
Okay. There are fines associated with the felony that you are charged with as it pertains to the other question that you are asking regarding the straw man account. I understand that that is your firmly held belief, that the government is a straw, or that you are a straw man for the government, but there is no, it's only as it pertains, there's fines associated with the felony. So if that's the question that you are asking, we don't know what those fines are yet because we do not know what you are going to be convicted of, sir. If you are going to be convicted at all. So that would require,
well, isn't it
that would require the court to give an advance ruling, and the court is not in the practice of doing that.
Isn't it fair to say, though, in your bench book or somewhere else, there's a reference point that would say for NRS 200.508, whether it's category A or B, what the maximum U.S. dollar penalty is? Is that not in there or somewhere else within your resources, Judge?
Yes, it is, but that was not a question that you had prepared for me to be prepared to respond to at this juncture. So I prepared for what you had put before the court, and I did not, and I've gone far afield of what you have actually put before the court properly today, and I think that I've engaged in your questions enough for today. If there's any additional questions that you would like to ask the court, you can certainly provide those via written motion, and then that way, the next time I will be prepared to provide you with a substantive answer the way that I was prepared to do so today on your other issues that you did properly bring before the court, because I don't like shooting from the hip, and I certainly don't want to give you incorrect information, sir.
Thank you, ma'am, thank you, Judge. And so all I want to say is by ending, and this is ending it, is that I respectfully object to your ruling on both of those motions to deny them, and that I take exception with both of those rulings, Judge.
Okay. And your exceptions are noted. Thank you very much. Have a good day.
Thank you. Thank you.